Thank you, one and all. This is going to be a terrific evening, and we're excited here at the Robert H. Jackson Center to host an event being the 75th anniversary of Attorney General Robert H. Jackson's speech, which has been entitled The Federal Prosecutor. How do these things happen? How does this event occur? A little backdrop, because the world of serendipity works well in the Robert H. Jackson Center. I wasn't going to tell this story, but Brent, you don't mind, he agreed it was okay to tell. And so our offices, Philip Slidell's offices, are on the second floor of the BWB building, and right next door to us, and we're a little nervous about this, but is the FBI. So we have the FBI. So one day I was looking at calendars, and I happened to note that April 1st, 1940, was a date where the Attorney General Jackson gave the speech, and I thought, you know, that's coming up pretty soon. So in the high sanctum of the second floor, being the men's room, I was there. Brent walked in, Department of Justice, FBI, DOJ. I said, gee, wouldn't this be great, Brent, if we could possibly consider doing this event honoring the 75th anniversary. It's divisible by 75. Not a lot of events are like that. And so he did what somebody would do, washed his hands, and then he went out and wrote an email to Bill Hochul, U.S. Attorney William Hochul. And U.S. Attorney William Hochul responded incredibly quickly and affirmatively, and the rest, as will unfold tonight, is history. So we're thrilled to be able to have U.S. Attorney William Hochul here. He's invited this august group of panelists to have this particular event, and along the way we're thrilled to have Governor Kathy Hochul here in our midst. Thank you. You add incredible prestige to the event. So thank you very much for coming. Plus, you brought Fred Andriaccio along, and I was told to mention him as much as I can tonight. Thank you, Fred, for coming down. So what do we have going on tonight? We have, hopefully everybody got a program here, which has within it the extensive biography of the panelists, together with a little bit of background regarding Robert Jackson, which of course you're here at the Jackson Center, and the Attorney General Jackson, and most important, a complete reprint of the Federal Prosecutor by Robert Jackson. A little bit about the panelists. As mentioned, the facilitator is U.S. Attorney William Hochul, the United States Attorney for the Western District of New York. He was nominated by President Obama for the position in 2009, and the Senate confirmed him unanimously in 2010. Does that happen much anymore? I don't think so. His resume, and I'll refer you to that, is extensive. But most important for a lot of our purposes tonight, Mr. Hochul served as the lead prosecutor, not only in several high-profile international terrorism cases, but it also included the highly successful prosecution of the internationally known Lackawanna 6, which was to a wonderful conclusion. And he came down to the Jackson Center and talked about that a few years ago, and we were particularly honored. Additional panelists include the Honorable John Cleland, a native of Kane, Pennsylvania, who currently serves as the senior trial judge. Judge Cleland was our Robert H. Jackson lecturer down in Warren on Jackson's birthday. We did an interview, which was terrific, and at that time we talked a lot about his career, but it also included the fact that he presided over the case involving the former Penn State assistant football coach Jerry Sandusky. Judge Cleland, as I mentioned, is currently serving as a senior trial judge, and previously served as the McKean County Court of Common Pleas from 1984 until 2008. And he was appointed to the Superior Court of Pennsylvania until he took senior status in 2010. Judge Cleland, thank you for coming. We also have David Foley. David was appointed as Chautauqua County District Attorney in 2005 by Governor Pataki to complete the remainder of District Attorney James Subjack's term. He subsequently won election in November of 2005, and he serves as one of 62 district attorneys throughout New York State. He's the top law enforcement agent in Chautauqua County. And his father, an attorney, and his grandfather, also an attorney. And as the story goes, your grandfather became close friends with Robert Jackson, and they often enjoyed each other's company in Washington, as stating they were the only two Democrats in Chautauqua County, especially as lawyers. And in fact, there's a chair outside, which is the Supreme Court chair of Justice Robert Jackson, and one Bill Foley had time and spent sitting in that chair to the delight of Robert Jackson while in Washington. So, David, thank you very much for joining us today. Mike. Those were the claps of all the defense attorneys. I want you to know that out there. Additionally, we have Mike Conley. Mike is the editor and vice president of the Buffalo News. He joined the newspaper in October of 2012. And before his career at the Buffalo News, Mike spent nearly 9 years as executive editor of the Herald Tribune in Sarasota, Florida. And under his leadership, the Herald Tribune won its first Pulitzer Prize and had 2 other projects that were Pulitzer Prize finalists. His career goes back and includes in 1981, where he started with the Wall Street Journal and has worked in New York, Miami, Chicago, and this is his very first trip here to Jamestown, New York. So welcome to Mike Conley. Thank you for coming. I want to thank, by the way, the various Inns of Court, which were helpful in not only the event that occurred prior to today, but also making sure this program became available for us tonight, and you'll see their names on the back. April 1st, 1940 marks the 75th anniversary of then Attorney General of the United States, Robert H. Jackson's great, enduring, much remembered, and much quoted speech, The Federal Prosecutor. Jackson delivered the speech to the assembled U.S. attorneys from across the country in the Great Hall at the U.S. Department of Justice. Jackson had worked in Washington, D.C. in high federal offices since 1934, having previously been a private attorney in Jamestown, New York for over 20 years. And for those that don't know, and this is your first crack, Jackson recently was the answer to the Jeopardy question, named the only person in the history of the United States to be Solicitor General, Attorney General, and a Justice of the United States Supreme Court. That's cool from a guy from here who never went to college and never graduated from law school. And as we also know, just in a quick, to tie up the biography of it all, he became the chief American prosecutor at the Nuremberg trial, which will be beginning to be celebrated, the 70th anniversary of it, starting in May. One plug, there'll only be one plug, that on May 4th we will be having the world premiere of a movie entitled Liberty Under Law, the Robert H. Jackson story, which will be here. It'll be the first time it'll be shown, and the next time it'll be shown will be on PBS. So we welcome you to come, and you'll be invited specifically for that. Jackson, in 1934, went to Washington at the behest of President Roosevelt. He became general counsel to what we now know as the Internal Revenue Service. He was in the Department of Justice there through 1936, and then he became Solicitor General. And then after that, he became Attorney General. And January of 1940, and in fact, if you didn't see it, where the reception was the actual appointment signed by President Roosevelt. and also included the nomination that had to be accepted by Jackson and other related papers. All kind of rolled out today, and thanks to Jen Champ. Jen, if she's here, thank you very much for pulling that all together. Robert Jackson, as the new Attorney General during the first months of 1940, was in a whirlwind mode. He rallied beleaguered Department of Justice colleagues. They applauded his appointment, which meant a restoration of the ethics and excellence that they valued in the Department of Justice. Jackson, on April 1st, 1940, with all of the U.S. attorneys assembled, gave this speech, which is reprinted here, and I will not go through all of it, but I think to set the stage for U.S. Attorney Hochul, I would like to read some of these. It would probably be within the range of that exaggeration permitted in Washington to say that assembled in this room is one of the most powerful peacetime forces known to our country. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimidations. Or the prosecutor may choose a more subtle course and simply have a citizen's friends interviewed. The prosecutor can order arrest, present cases to the grand jury in secret session, and on the basis of his one-sided presentation of the facts, can cause the citizen to be indicted or held for trial. He may dismiss the case before trial, in which case the defense never has a chance to be heard. Or he may go on with a public trial. If he obtains a conviction, the prosecutor can still make recommendations as to sentence, as to whether the prisoner should get probation or a suspended sentence, or after he's put away as to whether he is fit subject for parole. While the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst. These powers have been granted to our law enforcement agencies because it seems necessary that such a power to prosecute be lodged somewhere. This authority has been granted by people who really wanted the right thing done, wanted crime eliminated, but also wanted the best in our American traditions preserved. He concluded his speech, which has been used and recited throughout the Department of Justice and through the FBI and other areas as sort of the gold standard with this. The qualities of a good prosecutor are as elusive and as impossible to define as those which mark a gentleman. And those who need to be told would not understand it anyway. A sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power, and the citizen's safety lies in the prosecutor, who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. And a person who, in my observation, has manifested that quality is our presenter today, U.S. Attorney William Hochul.
Thank you, Greg, and most importantly, thanks to all of you who have journeyed here to really share in what is important, not just to me and the prosecutors of the U.S. Department of Justice, but frankly, and as I think we'll jointly discover today, of critical importance to all of you in the audience. But before we get to my remarks, let me first begin by also extending an extreme note of thanks and ask for your recognition of the continuing hard work of Greg Peterson, who joined with Brent Isaacson to make tonight possible. Can we have a round of applause, please? This was such a timely project for me and a thankful one to get this invitation, but I also need to add a personal note of thanks to both Greg and Brent, because it's one of the few occasions when I get to spend time with my wife in a public setting, And over the last 5, 6 years, this may be, with the exception possibly of this last Monday's Dingus Day celebration, the only time in memory when we have been together. So I'd like to also extend a welcome and thanks to my wife for coming. As you heard, it was 75 years ago that then Attorney General Jackson gave a speech to United States attorneys. He might have intended to deliver that message to my predecessors, the U.S. attorneys of the day. But I think before we're done today, you're going to find that in fact his remarks so resonate that they serve as valuable guideposts for all of you, not just the members of the public, but the members who are here who have joined us from the judiciary, from the law enforcement community, and yes, even from the media. In many ways, those remarks 75 years ago have transcended time and space. Now, Greg Peterson has given some highlights of what the Jackson speech really centers upon. And I'm going to talk about two aspects of Greg's remarks that he gave in his few moments with you. The first aspect of Jackson's remarks was an observation regarding power. Prosecutors, according to the Attorney General, have so much of it that they are perhaps the most powerful force that we allow in peacetime or in war in civilian authority. They can seek to imprison people. Certainly, they can investigate and charge those people. And the question always becomes, why give that much power to prosecutors? And Jackson provides a partial answer. It's because Americans, as in fact any civilized people want, is a reduction, if not elimination, of crime. Now, the 1940s, I think we can all acknowledge, were a far different time than we face today in the 21st century. Organized crime, thanks largely to the efforts of the media, was only becoming known, generally having risen up from our attempts at prohibition of alcohol. The ability to fight crime, though, was really at a very undeveloped stage. Brent Peterson, who's a member of the FBI, would be the first to tell you that the FBI of the 30s and 1940 was just a shadow of its organizational strength today, and in fact had only recently become recognized as a national crime-fighting agency. ATF was an enterprise known as a different organization, principally organized to combat alcohol, but like the FBI, was just getting underway. And some of our largest crime-fighting entities today, such as the Department of Homeland Security, it didn't even exist. And yet Jackson said that prosecutors had more power than any other entity he knew of. A remarkable statement. But I'm here to tell you that if Jackson said that there was power reposing in my predecessors 75 years ago, it's even greater today. You and the public need to know that. You need to know that of all the federal agencies, in fact, the local, state, county law enforcement agencies combined, collect evidence and tend to keep it within their own file cabinets. That's the way our criminal justice and crime-fighting tradition has arisen, and there's good reason. We want, as a society, to the extent possible, to protect people's privacy. We want to make sure that they're free from unreasonable searches and seizures, that they can enjoy all of the rights and privileges that are enshrined in the Bill of Rights. But if there is a stovepipe mentality among law enforcement agencies, that ends when a case gets brought to the prosecutor. We not only have the ability to collect the individual dots that the law enforcement agents and agencies collect, but we also have the ability to find and collect more dots than even they did. You heard about the secret grand jury procedures, and in fact, Justice Jackson, then Attorney General Jackson, mentioned that in the remarks that Greg gave you. But what Jackson really didn't experience, nor did any of the U.S. attorneys of the 40s really employ, was the wide extent of plea bargains that today we as prosecutors routinely do. Estimates say that perhaps 90, maybe 95% of all cases are the result and conclude in a plea. But at least as federal prosecutors, I can tell you that a plea never happens until we as the prosecutor thoroughly debrief what it is the criminal has to offer. More dots are collected that, again, the investigative agencies won't even get unless we share it. We're the ones who issue grand jury subpoenas and collect the information. We're the ones, in fact, who authorize some of the most intrusive techniques that my fellow police officers and federal agents use. Things like wiretaps. Did you know that in 1940 there was no wiretap law? That would take another 28 years before Title III would be passed, 1968. And even then, it wasn't really used extensively until federal prosecutors began authorizing agents to employ this technique. Undercover operations. And in today's world, international investigations, which require me and my fellow prosecutors to sometimes work with the intelligence community, the military, and law enforcement across this country and, in fact, across the world. Far, far more power than even Jackson anticipated. Now, a fair question for you to ask is, how is it going? How are prosecutors joined with law enforcement doing? Well, according to statistical information, you should be gratified to know violent crime continues to trend down. As a matter of fact, crime is now so low, we are approaching levels of the safest times in American history, the 1950s. And that is despite the fact that the American population has more than tripled since Jackson put pen to paper on April 1st, 1940. But a very good saying that I'm sure you heard and that all of us use is that with great power comes great responsibility. And that is, in fact, the second aspect of the Jackson message that I will speak of before I conclude. How is a prosecutor, whether it be a state or a county prosecutor, such as our distinguished Dave Foley, or one of the 93 presidentially appointed, Senate-confirmed United States attorneys, such as myself, how are we to exercise that power? Jackson provided, I think, part of the answer. He said you have to have a loyalty to the law and a strong belief in the Constitution. That's clear. But I would add a number of other ideals that prosecutors need to employ and that you in the public need to demand. First, there has to be a commitment and an awareness that any time a person is hurt, that is the most important event in that person's life, perhaps their family's life. And as a society, we have to do what we can to ensure that prosecutors get to the bottom of what happened. In 1940, for example, when Jackson said there was so much power, the only existential threat facing us was that posed by the Nazis. People like Rudolf Hess, who happens to be behind me. At the time, a commandant of Auschwitz concentration camp. My son and I have been to Auschwitz, along with the nearby Birkenau extermination camp. And speaking of that threat, which at this point in the 1940s, and in fact throughout the balance of the war, was still thousands and thousands of miles away, Jackson said the need for prosecution was because of this. The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. Well, if that was true of the Nazis, how much truer is it for today's Al-Qaeda threat, where Osama bin Laden in 1998 proclaimed it a religious obligation for he and his followers to kill any American, civilian or military, man, woman, or child, wherever found. Where one of his chief spokesmen, Suleiman Abu Ghaith, said that his personal goal was to kill 4 million Americans and maim and disfigure a like number of children. And where today groups such as ISIL or the Islamic State make Al-Qaeda, in perhaps a reverse of the words of our president, make Al-Qaeda look like a JV team because of their horrific violence across multiple domains and countries. Well, you need awareness, I would argue, of the threat. And you need a dedication to combat it, to go with the fealty to the Constitution in your prosecutors. Another skill you need is an ability to use the latest technologies against those who would hurt us. You know, today's computers, which unfortunately each of us have in our own pockets, probably in this very room, has made the earth almost flat in both terms of time and space. Criminals, not just terrorists, attack people here in Western New York every day. But what I say prosecutors need to do is they need to educate themselves and turn those tools against the criminals. And I'm pleased to report to you that all of the law enforcement agencies that are working for you and are paid by you, agencies that are represented here by people such as Sheriff Tim Howard from Erie County, Sheriff Joe Geraci from Chautauqua County, we have Scott Ritchie from the New York State Park Police, Fred Angiriaccio from the New York State Police, and on and on. We are using that technology and trying to attack criminals before they can strike, and certainly to eliminate terrorist threats wherever possible. But if a good prosecutor needs this felicity with computers and with science, the difficult thing about being a prosecutor is you need almost equally strong, if not more so, skills at the opposite end of the spectrum. You need a human touch, the ability to work not just with kings, but with paupers. Because victims, defendants, lawyers, judges, they come from all walks of life. And I also think about some of the strengths that prosecutors such as Dave Foley have to have as he works even in a relatively peaceful county such as this, with some of the most horrific crimes that I even hear about across 17 counties. He not only guides his office to take on those threats, murders, and so forth, but he sometimes personally handles those cases. And think of the strength it takes to be able to live in a case, to present it to a jury, and then to move on to the next one. A phenomenal, phenomenal skill to be able to manage that at an emotional, a physical, and a mental level. But you know, prosecutors are up to the task. And I believe they're up to the task in part because we have very strong defense lawyers. Defense lawyers who have read Jackson's speech and who have also endorsed the idea that prosecutors win not just when a criminal is convicted, but perhaps more importantly, when justice is done. And if that in fact is the ideal, as it should be, that means whether or not a prosecutor wins or loses should be immaterial. And if a defense lawyer isn't holding us up to that standard, I guarantee you the media and the judiciary will so hold us to that standard. And that standard of making sure justice is done requires protection of the defendant's rights. Rights like presumed innocence, innocence which has to be overcome only by such a great quantity of evidence that it's beyond a reasonable doubt. Standards which really keep a prosecutor in Jackson's image from indicting a case only when that evidence has been satisfied. Making fair arguments to a jury, and then at sentencing, making sure that the victim's voice is heard so that a just punishment can be imposed by the court. And in one last instance that Jackson couldn't even have dreamed of, dealing with today's 24/7 media industry. Because we have wonderful established news outlets, such as the Buffalo News, and we're so fortunate and frankly lucky that the Buffalo News saw fit to steal editor Mike Connolly and bring him to Western New York to shine the light of day on the criminal justice system, or the Jamestown Observer. But frankly, we have bloggers, we have internet sources, we have talk shows, and hundreds of other ways of disseminating information. Sometimes, as we have all read about, the information is simply wrong. And sometimes that wrong information has literally led to chaos in some communities. But through all of that, it is the prosecutor's job to not pander to either the community or the media, to do his job and to do justice. Now, let me conclude with one last observation. You know, here we are, and we have almost a full auditorium, 75 years after Jackson gave his remarks talking about the role of the prosecutor. I think it's fair to say, if these principles are so powerful, that 75 years from now, it very well may be possible that your successors and family members will be gathered, perhaps in this very space, to once again reflect on what Robert Jackson said that long, long time ago. And if I'm right, that in fact these words live on, what we all would have witnessed is that in fact the words of our own Robert Jackson have themselves transcended time and space. And I also think that just as it's my privilege to be here today among you, we will all consider ourselves privileged to realize that once upon a time, a man from our own communities, a man who sat in this very auditorium, uttered words which not only have guided federal prosecutors for over a century, but they have in fact provided the standard by which you in the media, the law enforcement community, the judiciary, and the public should expect and demand from one of the most important of public officials working for this nation. Thank you very much, and I will turn it over to Greg Peterson.
Wow, thank you very much. That was terrific. And now we have an opportunity to have our U.S. Attorney lead a little conversation with these three distinguished panelists. I've seen a little bit of what they're going to think they're going to chat about, but an awful lot. And also I want to point out that there will be an opportunity for Q&A. I will have cards, and I'll be sort of standing around. If you want to raise your hand, I will make sure that you get a card. We'll do it Chautauqua institution style, so you can pass it to me, and I'll have a chance. If there are three same questions, we'll be able to vet through that. So with that.
Well, now's the time when all of us get a chance to really ask what's on your mind of representatives of all the different industries that I've spoken about. Introductions have been made, but just to repeat, we have Judge Cleland, a longtime distinguished member of the judiciary. We have our own district attorney par excellence, Dave Foley, who has not only personally handled these cases, but runs the office which keeps this area safe, the chief law enforcement officer for Chautauqua. And then we have a very distinguished member of the media, but who also is a member of the public, extremely well-read, a very good friend in Mike Connolly. So by all means, take advantage of this panel. Who knows when such distinguished guests will be sharing the same podium and available to you. But to get it started, I thought I would ask the preliminary questions. And out of courtesy to my position as the district attorney, I think I will, or the U.S. attorney, I think I'll go to our district attorney. Dave Foley, obviously we've been speaking about how you've been the district attorney now for almost 10 years, in fact, probably beyond 10 years. Can you talk about your role in the criminal justice system? How it is, or whether it is you use principles such as the Jackson principles, whether or not your job and role has changed over time, and share with the public things that you need them to know about your position.
Thank you. Yes, I've gone over the speech by Robert H. Jackson. I find it very interesting, and as you had indicated, really transcends time and space. I like the way that it develops in that he describes the powers of the district attorney first and foremost, indicating what we're capable of doing, convening grand juries, bringing people to trial, these things that I think most people accept as being an accurate description of what district attorneys can do. And I think it's a description that basically the public in general accepts as district attorneys, this power, this ability to bring people to answer to charges. But what he does then is he goes on, and it's really wonderful in his speech when he starts to require or indicate that what makes a good prosecutor is a sense of justice, humility, and a lack of malice. And I think those are key factors that he points out within his speech that prosecutors need to possess. A few years ago, I was interviewed by a fourth grader for an elementary newspaper. And at the end of the interview, he said, "Why do you like to be the district attorney?" And my answer was, "Because it makes me feel a little bit like Superman." It's fourth grader. And I explained that because it makes me feel good to help people, to put away bad guys, if you would, to vanquish the defendants, but also help victims. And that gave me a sense of pride, gave me a sense of purpose. And I think in that vein, it sort of describes the first portion of Robert H. Jackson's speech, what I can do. But I have another philosophy that sort of goes along with the Superman, and that's truth, justice, and the American way. First, and these are the principles that guide me as the district attorney, I seek the truth. Incriminating, exculpatory, whatever it may be, I need to know the truth. When I go into trial, my simple purpose is to ascertain the truth. When I'm assisting in an investigation with the police, my purpose is to find out the truth. Not to hold someone responsible for committing a crime, not necessarily to find someone that hasn't committed a crime, either one. Anything that is usable by me to determine that. Second, I seek justice. Unlike most attorneys, I don't have a client, or maybe better said, all of you are my client. I don't necessarily have to be answerable to victims. Do they have a say in what goes on? Certainly they do. Do we care about victims? Absolutely. Do we engage them in conversations as to how the case is going and propose what we can do, make offers? Certainly we do. I like to have meetings with victims. I meet with them often. And what I generally say to them is, I want you to participate in what we're doing. I want to know what your thoughts are. But I also explain to them that ultimately the decision rests with me. Typically, I find that most victims are satisfied with that and happy with the fact that I'm going to be making those decisions. What we do is we represent society. I represent all of you. I represent everyone within the jurisdiction in which I prosecute. And in that vein, my job is to seek justice, to do what is best for society. The American way. What I would describe the American way is upholding the Constitution. America is based upon the Constitution. And so it's very, very important to me to make sure that in the process of law enforcement, criminal investigations, prosecution, we uphold the ideas that are enumerated in the Constitution. Everyone's probably here familiar with the case of Ralph Bucky Phillips. Mr. Phillips, during my first year in office, luckily enough for me, shot 3 state troopers in New York State, 2 of them in Chautauqua County, killing one of them. And ultimately, law enforcement apprehended Mr. Phillips. And what ran through my mind at that time was, are we protecting his rights? Because he has rights too. And part of my job is to make sure that we do that. Have you Mirandized him? Have you indicated what his rights are? And they had. And we were able to get a statement and a confession from this individual at that time. Now, is it important to me that they Mirandized Mr. Phillips in order to get that statement that we were able to use to successfully prosecute him? Absolutely. But more importantly to me is that if I were in the same position that he was in, that my constitutional rights would be protected as well. So that's part of our job as prosecutors. I saw an article last week come online, I believe it was Alabama, and there was an individual down there that was convicted of a crime in 1985. And 25 years later, his conviction was overturned, and he was set free based upon, I believe it was faulty ballistics evidence. And I think to myself, when I read that article, I don't want that to be my legacy as the district attorney. And I'm not blaming any blame or fault, and you never know if something like that may happen to you. But I think it's our job to safeguard against those things. It's our job to make sure that those types of things don't happen. And at the end of the day, when I talk about a sense of justice, having humility, and a lack of malice, I can't sit here and tell you, all of you, that I have those attributes necessarily. But as what Judge Jackson does in his speech also deals with this, and he says, that's going to be left to my peers to decide. Members of the defense bar, fellow attorneys that are going to come forward and say, did he seek justice? And I certainly hope that the answer to that is yes. But those are the principles by which I run my office and have my ADAs operate on their day-to-day job.
Thank you, DA Foley. Judge Cleland, I'll turn to you next. You're a distinguished member of the judiciary and obviously familiar with Jackson and Jackson's speech. Does it almost seem that if the DA is doing his job, we don't need a judge? Or since the answer to that is probably apparent, what is your perspective on how DAs are doing their job? Can you perhaps maybe distinguish that from defense lawyers' role in the criminal justice system, and any suggestions you may have as to how DAs, such as myself, could do our jobs better, or what the public has the right to expect, for that matter?
As you were making your opening remarks and projecting out another 75 years when people might still be listening to Jackson's speech, I was reminded about an opening that Jackson gave in a speech, another speech that he gave in 1940. And he said that in Washington, more people give speeches than listen to speeches. So, it's interesting to me that this is a speech that we're listening to 75 years afterwards, and I agree with you, we're going to be listening to for a long time to come, because he touches on certain very fundamental issues that are important to all of us as citizens of a democracy. In terms of what I, as a judge, expect of a prosecutor, I think that what all of us should expect, but from my perspective, that I expect the mindset of an advocate, but an advocate that has judgment and maturity and a dispassionate perspective on the issues that are being presented, and behave in a way that builds confidence in the system and in the rule of law. That is a gift if people can do that, can behave and act in an articulate and forceful but respectful way for the interests that are involved. And some people have called that a sense of gravitas. That difficult word to define, I guess, but to me it means patience and stamina and weight of judgment about what is required in our system of justice. But to say that, I think, begs the question, and we use words sometimes that we don't think very carefully or think through carefully enough about what they mean. For example, justice. What is justice? It's a word that we all use, but not frequently stop to try to define what that means. Too often, justice is a result we agree with. So if there is a result that we agree with, we say justice has been done. Mm-hmm. If there is a result we disagree with, then there has been an injustice. I would submit that it's a much more complex analysis than that. And Jackson takes a stab at that. And he talks about justice being accomplished in a form of sportsmanship and fair play. And I think that's what these prosecutors were talking about here in that way, in terms of the way that they're using justice. But we're not always as fortunate to have prosecutors as enlightened as these two, who have a more less sophisticated view of justice because it's so easy to be hard. And to too many in law enforcement, being hard is being just. And I'm not sure that's always the case. And I think no one could have said it better than Mr. Foley a few minutes ago. So from my perspective, that's what I like to see. That I have confidence that a prosecutor is being careful in investigating and thinking about not only the facts of the case, but the implications of that case, not just for the victim, not just for the defendant, but for all of us. And sometimes that is a very complicated calculus, and it takes some careful reflection and thought.
Thank you, Judge. Mike Connolly, a member of the media, I was trying to think of any aspect of the criminal justice system that prosecutors, whether they be district attorneys or U.S. attorneys, interact more with than the media in virtually every single case. Certainly, when we finally present a case and charge it, we appear before a judge and there's a defense lawyer. But long before there's a criminal charge, there are occasions when the media is trying to shine the light of day on what's happening in a particular crime episode. And invariably, your reporters will run across our prosecutors. Could you share with this audience, perhaps, from your vast years of experience, what are those interactions like? Do prosecutors do the right job when they're interacting with you in the media? Your role, of course, is to make sure the public, even if they can't be in the courtroom, knows what's going on. But yet there's probably times when your reporters come back to you, and maybe you yourself was frustrated with what a prosecutor is willing to say or not say to you and then inferentially the public. Can you share your insights on some of those topics and how they may relate to Jackson's remarks?
First of all, thank you for having me here. It is delightful to be here. Every reporter dreams of being in a room full of prosecutors. I don't believe there is any reporter or editor who would be completely satisfied with a prosecutor delivering anything short of true confessions. That is the nature of what we do. For the most part, our dealings with prosecutors on the cases in front of them follow a pretty standard routine. We want to know more. We want to tell the full story. There is, your interest is to protect the process. And that oftentimes leads you to want to hold things back until the right time. Interestingly, some of the issues we have with what you do as prosecutors, and it was, reading the Jackson speech was fascinating for me. I had not read it before. And the section on discretion struck me particularly. And in newsrooms, oftentimes our larger conversations are around those issues. Let me just read the passage. What every prosecutor is practically required to do is to select the cases for prosecution and to select those in which the offense is the most flagrant, the public harm the greatest, and the proof the most certain. As we approach our reporting, 30 years of reporting and covering law enforcement, there's three areas in particular where I see sort of systemic things, where there are at least concerns about how discretion is used. One is prosecution of white-collar crime. I came from Florida. We used to say in Florida you were more likely to land in jail for stealing $5,000 than $500,000. We wrote stories about large-scale fraud schemes in the housing market that were a contributing factor to the housing meltdown. We wrote stories about insurance companies colluding to raise rates and cost Floridians hundreds of millions of dollars. Those are very hard cases to prosecute, and they require the kind of skills that were talked about familiarity with computers, ability to dig into financial documents. Oftentimes, those large sort of systemic things don't always seem to get the attention that other things, that violent crime does. A second area is what I would describe as sort of the needle in the haystack crime. One of the things that modern data lets investigators do, whether they're in newsrooms or in law enforcement agencies, is put together the haystack and then search for needles in the haystack. And oftentimes in the search for needles, you find fascinating things. I've been involved in projects where we assembled a database in Florida of teachers who had abused students. And what you find when you put that database together is that oftentimes there are teachers who do it once, get fired quietly, go on to the next place, do it again, get fired quietly, go on to the next place and do it again. And that may happen as many as half a dozen times. Looking at that systemically and putting together the haystack and then finding the needles can prevent a lot of people from being injured in the future. We did the same thing with police officers in Florida, much to their dismay, I might add, and found, for example, a police officer who had been involved in more than 40 serious incidents and yet was still in the job. And in fact, when our reporter went to see him, he boasted about how bad he was, but what a good cop he was. And then the third area that we've sort of seen over the years are political concerns. The fact that in so many states, and I've been a journalist in 5 states in the District of Columbia, in so many states, prosecutors are elected. And one can never know what is going through a prosecutor's mind when they make all those decisions involved in discretion. But it inevitably raises questions about the process.
Mike's comments, DA Foley, are so intriguing, and I love that he focused on discretion of prosecutors and how sometimes cases which are even reported on in the paper, episodes, aren't investigated. Could you perhaps expand on how you exercise discretion? I know the Attorney General's comments, we're not supposed to be concerned with wins and losses. How does discretion play into the Jackson ideals? And do you think there is some hesitation perhaps by elected DAs to go after certain targets?
Well, I mean, ever since I was elected district attorney, I always have operated with the sense that that was my last term. You know, it's not about being reelected. It never can be about being reelected. If you start to grow concerned about that, then you're not doing your job. Discretion housed in a district attorney with the ideals that are espoused by Justice, or then A.G. Jackson, it's wonderful. You need to have discretion. I mean, there's literally no way, and it really, you know, 75 years ago, Jackson couldn't even anticipate the number of cases, for example, that we open and the amount. I mean, as you had indicated, law enforcement has grown exponentially since then. And prosecution offices, I'm not really sure, have grown with that. So the number of cases that we receive, it's large, and we need to have the discretion to be able to make decisions on cases. And when you talk about the what I call the dirty word, plea bargains, you know, it's necessary to do that. But remember, oftentimes police will go out and make a charge. Of course, the burden for arrest is based upon probable cause. We oftentimes will look at that case, and we need to make a determination. Can we sustain a conviction? I'm not going to take a case to a grand jury unless I believe that I can prove that case beyond a reasonable doubt. Of course, what happens is once someone is arrested, it hits the media. Newspapers report on it. TV stations want to do interviews with you. Of course, you're trying to maintain the integrity of the case, so you speak very little by saying, I can't comment on that. And it creates this cycle. And you don't want to appear to be hiding information, which sometimes, of course, you're afraid of. But sometimes you need to make the decision, we can't move forward on the case. And honestly, when media asks, most of the time I have to explain, hopefully nicely, I can't tell you why. Because you're not sure whether or not maybe more evidence will be revealed. Maybe at some point you will be able to maintain a prosecution on it. So, you know, it becomes difficult. But I think you can't be in the job and not have discretion. Now, if there's prosecutors out there who don't live by the ideal, then it becomes an abuse of power, and that's unfortunate. We're like any other segment, I suppose, of the population. Some of us are good, and some of us aren't so good. And I guess when it comes right down to it, I would prefer to have the population that I represent elect me into that position and know that I'm living by, hopefully living by the ideals as set out by A.G. Jackson.
Judge Cleland, this discretion, which Justice Jackson said in many cases is unreviewable. From your vantage point now as a judge for so many years, should there be perhaps a role for courts, a greater role for courts in some of these discretionary calls? When and where do you engage in the process of typically discretionary areas for prosecutors? And then perhaps, not to compound it too much, but are there instances you've seen where judges have had to step in? And I'm thinking of really judge-imposed rules like the Brady obligation, to just name one.
Well, you touched on an interesting question earlier on. Is there a need for judges anymore? If prosecutors have so much discretion and so much power. But one area that prosecutors have tremendous discretion now that they didn't have in Jackson's day is in the area of sentencing, because the legislatures and Congress have enacted mandatory sentencing for so many offenses, so that if a prosecutor charges a crime with a mandatory sentence, the judge's hands are tied. So when Jackson speaks in his speech about using his influence to hope that a judge will impose a certain sentence, that's not true anymore. Now, the prosecutors, in many instances, have the ability to tie a judge's hands completely. Now, I'm not saying that they use that improperly, unfairly. I'm not suggesting that at all, but it is frequently a fact. So in one sense, the sentencing process, the sentencing decision of the court is one relief valve that sometimes can come into play, sometimes at the request of prosecutors. We'll say, Judge, I need this felony conviction, but I don't care what the sentence is. I don't mean need it for political purpose or anything like that, but it's important that the defendant, for whatever reason, plead guilty to a felony in this case, but I don't care if he necessarily goes to prison. So there is that relief valve that is available not just to prosecutors and defense, but also to defense. But part of the fairness of the process you touched on the Brady Rule, and the Brady Rule is a case called the Brady versus Maryland in the 1960s, where a fellow named Brady was charged with murder committed during a robbery. And he went to trial. His co-defendant had a separate trial. They were both sentenced to death. Brady's defense lawyer had asked the prosecutor for any statements that the other defendant had made, and they gave him all the other defendant's statements except the one where the other guy admitted pulling the trigger. The Supreme Court said, no, you can't do that. If a prosecutor has exculpatory information, it has to be turned over. That's part of the fairness. That's part of the seeking the truth that we're talking about. And so that is a very, very important part of our process. And we touched, Mr. Foley touched a minute ago on that case from Alabama, and I happened to see that same article. And this is what the prosecutor wrote just a couple weeks ago. Based on what we had, I was confident that the right man was being prosecuted, and I was not going to commit resources to investigate what I considered to be bogus claims that we had the wrong man. My mindset was wrong and blinded me to my purpose of seeking justice, rather than obtaining a conviction of a person who I believed to be guilty. I did not hide evidence. I simply did not seriously consider that sufficient information may have been out there that could have led me to a different conclusion. And that's the responsibility, the burden that these prosecutors bear, is to make sure that that investigation doesn't target someone unfairly, so that they don't have access to the information that prosecutors have that can lead to their own exoneration. In this case, this fellow had been in prison on death row for 35 years.
Mike, you mentioned in your remarks a couple of areas from your experience where it seemed like prosecutors were either treading lightly or not at all. You mentioned the white-collar area, the needle in the haystack area. You mentioned the political corruption area. Perhaps an area that has dominated the 24/7 news cycle of late are police excessive force cases. And there has been some commentary in the media that perhaps district attorneys or prosecutors, because they are so close to the cops, maybe in those cases we need to consider independent investigator prosecutors or what have you. First of all, what do you think about that idea? Are prosecutors doing okay in the area, and I know it's a broad topic, of police excessive force cases? Does the media ever hold prosecutors accountable when they're not handling cases, either such as the ones you mentioned, or these maybe more contemporary excessive force cases we're reading about?
Gee, do we ever write about those things? I think that's a really interesting question, and one of the things we always try to be careful about is finding motive when we don't actually know where it comes from. So, do these cases not do cases of police excessive force or police misdeeds not get prosecuted because prosecutors are close to law enforcement officers, or are there other reasons? I don't know, but I do think that there are ways to find them that go beyond kind of traditional methods, and it's the needle in the haystack approach. And it is so easy to do these days, if you keep data that logs every case that happens and regularly review that data, you will find patterns that lead you to prosecutions that may not have happened otherwise. It's a fairly new thing. Databases have been around for 40 years, but they've only been easily accessible for people for 10 to 15. Cultivating those skills, I think, can erase the question of, is it motive? Should somebody else have to do it? If it just becomes a different part of a new and different part of the process, you will find amazing things.
And I understand that, and I appreciate that. Of course, the complexity in that not only comes up when you talk about, as prosecutors, what we're able to divulge to the media, which of course can be extremely limited, but you also look at and at least in my perspective, what I try to do with media, if I have the opportunity to do it, because they don't always know. Their job is obviously different than being a prosecutor, is to try and educate them some. So sometimes you get, just for an example, and a media outlet may say to me, well, allegedly he's done this before. Let's take a DV case, for example. Allegedly he's done this before, but no arrest occurred for whatever reason, we don't know, but there might be evidence of it somewhere. And of course, if he did it before, he must have done it now. But of course, then you have to go on to explain that we're not allowed as prosecutors to use propensity evidence to prove a current crime. And so you get caught in these situations where you're trying to explain to someone, well, I understand that, but I can't use that. And so, if he's done it 15 times, great. Now, there are some exceptions to that. but, it creates difficulties as prosecutors, because to try and educate people on what the system allows us to do and not to do can be difficult. It can be, I think, difficult for media sometimes to understand. It certainly can be difficult for victims to understand. But part of our job, obviously, is not only, I think, to educate the media, but hopefully effectively communicate what we're capable of doing to victims, for victims as well.
Yeah, I'd like to just jump in on that too, because I think that the responsibility of the media is so important that as those of us involved in the court system, we have a responsibility to work with the media within our constraints to do that. And I'll give you a very good example of this. A number of years ago, 2009, I was appointed chairman of a commission, an intergovernmental commission to investigate judicial corruption in Luzerne County, Pennsylvania. It became known as the Kids for Cash scandal. And 3 judges there ultimately went to two of them ultimately went to federal prison for accepting some $3 million in kickbacks to put kids in detention centers. And that came to light largely because of the work of 2 newspapers in Wilkes-Barre, the Citizen's Voice and the Times Leader, who had reporters that doggedly investigated not just the actions of police and district attorneys, but of the judges, because the judges were at the heart of it. And if it hadn't been for the work of those newspapers, what was no other way to describe it, a total collapse of the rule of law in that county, would not have come to light and been corrected but for the work of very courageous reporters. They should have won the Pulitzer Prize for it.
And a little closer to my office's work, we relied on the media to expose what they were reporting were decades of corruption in Niagara County, where a particular labor union had completely cornered the market on construction. And unless somebody was willing to pay for work to be done, the work wasn't getting done. And it was thanks to the media that we were able to get leads. Now, the media would be pressing us continuously, well, what's happening with this case that we're reporting on, as egregious as it is? And as the DA said, we couldn't mention our progress, but fortunately it did come to conclusion. But Dave, I'm thinking, and maybe Judge Cleland as well, even beyond the excessive force cases where a police officer to some extent has abandoned his role as a protector and has become a defendant and a criminal in his own right, do you see other cases, though, perhaps where evidence wasn't secured properly? Maybe there's a violation of a right, a constitutional right. What do you do with police officers when they present you with good evidence? The man that they say was in possession of the 5 kilograms of cocaine, by goodness, it was in his car, but you have some questions about that.
Well,
do you have interactions
No,
like
sure,
that?
sure. We have what's called a suppression hearing to determine whether or not the evidence was seized in violation of constitutional rights. And let's suppose it was. Let's suppose that guy was caught with 5 kilograms of cocaine in a car.
He did.
Worth millions of dollars.
He did.
No question. The evidence gets suppressed, he walks, or she walks. That gets us back to our definition of justice. Was justice done? A guilty person, guilty in the sense that, no question, they possess this heinous illegal substance in a huge quantity, but they walk because the Constitution says that they should. And is that justice? Is it a result you agree with or disagree with? Is justice a more refined concept than simply does the guilty get off because the constable blundered?
Dave, what do you do with that? Do you drill down on that kind of information first?
Well, as the Supreme Court said, there's no right without a rule. And, unfortunately, it will happen. And if it does happen, it's my obligation, as I said before, to make sure that, number one, if it occurs, we need to shut that down. It's my responsibility as the district attorney to protect everybody's constitutional rights. And if a mistake was made, we don't proceed any further. We either stop the case where it's at, we advise defense counsels what has occurred, and we won't oppose a motion to dismiss if we feel it's appropriate. It's not a perfect system. These things happen. But it's also why, at least in a county of this size, on the bigger cases, and I will say it rarely happens, and our police agencies in Chautauqua County are wonderful. I'm on scene at homicides. I go to them because you want to make sure that those types of mistakes aren't made. We make ourselves available. Most police officers didn't go to law school, so you can't have the expectation that they're going to have the level of knowledge that we have in regards to the constitutional protections. And I know some defense attorneys out here would, shudder at this, but I'm kidding. We are there to protect constitutional rights of anyone accused of a crime, because it goes back to what I said before. If it was a loved one of mine that was accused of a crime, I would want them to be afforded those protections as well.
Mike, the last specific question before we either turn it to the audience or have some concluding remarks from our panelists. This whole idea of discretion, plea agreements, it sometimes seems that that's the end of a case. How is this discretion serve the public good, or does it serve the public good? Do you, as a member of the public or the media, do you think tweaks, changes, different strategies should be used, could be used by prosecutors? What do you think? What's your vantage point there?
It's the vantage point of one person who has been a reporter and editor for a long time is that discretion is a vital part of the system. One of the things that struck me in reading the Jackson speech was his brief mention of traffic violations, and thank God those aren't all tracked. But what's most important, and what we try to be a watchdog of, is that discretion is exercised with wisdom. It's so much fun sitting here because clearly we're with people who exercise it with wisdom. Our role in this great system of ours is to shine a spotlight, and when people don't exercise it with wisdom, make sure the world knows.
And let me just say, speaking for all the police who are also equally distinguished and extremely accomplished here, and perhaps speaking for Dave on this one, we appreciate when the media does point out where we could have done better, or where, thanks to the reporting, the bad actors are removed from the public domain. Really, that is something. Sometimes because of the limitations that we have, we can't get to that place, but it is a critical role. I see our Greg Peterson there with a whole stack of questions. Greg,
I got
fire away.
questions. I try to vet them so that some of them just don't find their way to this question, but here's one that was just 3-starred, and it's from Brett Isaacson. He just simply wants to know, how am I doing? That's for you, U.S. Attorney Hochul.
Let me tell you about Brent Isaacson. I shared this story earlier. There was a case, I believe it was out of Chautauqua, no, it was out of Cattaraugus County, neighboring county, where a man was accused of a murder of a particular friend of his, a former best friend, actually, by the name of Andy Gaspar. The defendant was Randall Knight. Randall Knight was charged by the then district attorney of Cattaraugus County with murder, and the jury acquitted. Our own Brent Isaacson, based here in Jamestown, was such a good agent, dedicated, that he did not let that murder go unavenged. 16 years later, he got the man, Randy Knight, who had been acquitted, to not only confess that he did do the murder, but he then brought the case to us where we were able to convict him of federal murder for hire, and he found out what was really behind the murder, and that was Andy Gaspar's wife, Cheryl Gaspar, who had arranged the whole thing. Brent Isaacson got her to confess to it on videotape. That's how he's doing.
You'll like it. Here's a question from Judge Lamancuso. Your thoughts on U.S. Today's reports on DEA's subpoenas to cell phone companies to harvest cell phone communications going back 2 decades into the 90s, which was coordinated with the U.S. military to track drug trafficking, and that the program was secret, without court orders or court oversight, and served as a model for the NSA. Is this a violation of the Fourth Amendment?
Well, I can never opine without knowing the facts, and I confess I haven't even read that reporting yet. I know it's out there, and I do need to get to it, but I can tell you that there's different kinds of data that is available in the cellular telephone world that requires different types of court process. But unless the person who owns that cell phone or that telephone consents to give all that information freely, regardless of the type of content, there is some court order or process that's required. Let me give you some examples. Just finding out what numbers were dialed by a cell phone over any length of time, the process there is a grand jury subpoena. Grand jury subpoena is a particular type of authority that the prosecutor is empowered to invoke on behalf of the citizens who are in the grand jury. If the content, though, that's sought is in some way of more than just numerical information, but maybe is text information, such as, send me the suits, do you want 5 or 10? Something like that. Then that requires a judge, such as Judge Cleland, upon a showing of probable cause, to actually issue an order. And then I would give that order to the agency, and the agency would collect that type of information. The most intrusive kind of information that we can get in the government, federal government, is where it's real-time conversation. And in that level of intrusion, we call that a wiretap. We have to first get authorization from the Attorney General in Washington or his designee, the Assistant Attorney General for the Criminal Division. Then we go to a judge. We have to show the judge there's probable cause of 3 things. Number 1, the phone that we want to listen to has been used in a crime before. Probable cause that it will continue to be used. And probable cause that the people we're about to overhear are engaged in the crime for which we said there's been this ongoing pattern. So it's kind of a high standard. Even when we get the authority, we can only do it for 30 days. But even that 30 days is broken up. Every 10 days, we have to give a progress report to the court. And if Judge Cleland, for example, says, you know what, this phone, that hasn't been used for crime, that's it. It's over. We pull the plug. End of interception. So without commenting directly, I can on the report, I can tell you that's how, in this district, in this U.S. Attorney's Office, the ways we get information.
Judge Cleland, I know I've seen a couple of opinions that you gave during the Sandusky case. This was part of the motion practice and motion decisions, where in fact you cited the Robert H. Jackson's federal prosecutor. What was the context of that?
The context was really to remind everyone involved in that very high-profile case the stakes that were involved. That sometimes early on we have to define the parameters of our perspective so that we don't get caught up in the process and the result of a particular case and forget about the law and traditions and constitution that bind us together as a people. And in that particular case, at that particular time, I thought it was important to present that reminder.
One here for you, Mike. Just simply, how's Rex Ryan going to do this year?
Rex is going to be a great story, I guarantee that.
Nothing to do with anything. U.S. Attorney Hochul, based upon your experience fighting international terrorism, how much damage has Edward Snowden done to the U.S. security around the world?
That's another one that would be difficult for me to opine, because obviously the people that have the information and its potential value are the ones that we have as our leaders in either the NSA or the intelligence community, such as the CIA or the President of the United States. And relying on their statements, and I would have no independent knowledge of what some of the content and its degree of classification and sensitivity was, those leaders of ours have said it's had very grave implications for our ability to capture terrorists, to prevent terrorist activity. And because the terrorists today do plan such unspeakable evil for all of us on a scale that is literally existential, and where the adversary says not only is it our religious obligation to kill us, but if we die trying, we still bypass the judgment seat and go straight to heaven. That really requires prosecutors, investigators of all sorts, from the locals all the way up to the feds, the military and the intelligence community, to do everything possible to prevent and preempt before it even happens. I forgot the great philosopher who said that the American Constitution is not a suicide pact. And if you are working in this space of counterterrorism, I can't imagine a more stomach-churning, heart-rending area to be working on, because you live with these threats that are reported sometimes by the media, and a range of threats which you can't even imagine. And that is the role and the life of prosecutors in these spaces. And by the way, before you think that it's kind of an abstract concept, I don't know how many here would know, but the very first ISIL recruiter captured anywhere in the United States, and perhaps anywhere in the world, was captured right here in Western New York. And our office, as we speak, is prosecuting Mufid Elfki for trying to send terrorists to fight with ISIL. So it's not that abstract. And putting aside ISIS for a while, putting aside Al-Qaeda for a while, you should also know we've had terrorists try to leave Western New York to blow up people in Israel on behalf of Al-Aqsa's Martyrs Brigade. We've had other terrorists who have attempted to go through Western New York to aid the Tamil Tigers, the LTTE, it was known as. So we have had any number of terrorists that have been prosecuted here, removed from here, come through here, and the world really is a very, very small place and flat, especially here in Western New York.
Final question I have is, this is for all the panelists. What's the question you were most concerned that you might be asked tonight?
How many traffic violations?
I'm not going to answer that. I invoked my Fifth Amendment right.
I guess that's just a question. I never occurred to me that there would be some question that would be inappropriate or wrong to answer. I don't have any answer, but I have a question.
Sure.
Maybe a concern. I'll put it this way. And I know we're not on the record, are we? We don't.
No, not at all.
Oh no.
Didn't you sign the consent form?
Let me take. I want to talk about this terrorist threat, because it's certainly a very serious problem. But I'm interested in your insights about how we think about this. Are there any analogies today with the communist threat of the late 40s and early 1950s, where the concern was about spies and Ethel and Julius Rosenberg and the communists taking over China and infiltrating into Southeast Asia and the arms race and so forth, led to certain excesses which 50 or 75 years later we regret. How do we think about that experience in terms of what's going on today?
Well, in some ways, I suppose you could analogize it, because Khrushchev's articulated goal was to crush America and to spread communism throughout all the land. But the point of departure would be this. At the end of the day, the communists of the 40s and the 50s, as well as political terrorists throughout history, and there's been terrorists throughout history, let's make no mistake, going back to the ancient Greeks, perhaps including the Zachariae at about the time of Christ, the so-called daggermen, going on perhaps to the people's will of ancient Tsarist Russia, who tried to use the theory of the bomb to overthrow the government there. The anarchists, of course, we know here at the turn of the 20th century, because, again, Leon Golgaz showed that Buffalo would not be spared from terrorist reach when he killed President McKinley. But unlike all those terrorists, there never was the religious motivation and articulated goal that what they are doing is righteous, that they will go to heaven if they fail or succeed, and that we, the adversary, are the devil. That's the difference. Now you're talking eschatological terms. Now you're talking beyond right and wrong. You are justifying any conduct of any type against any people. Terrorist technique always preys on the weak in order to inspire and to inspire other followers, like-minded, but to raise the fear of the targeted population. Today's terrorists, though, because of both the military or the religious motivation, combined with the media's ability, unwittingly perhaps, to perpetuate the fear through constant news cycles, talk shows, newspapers, I think increases the ability of terrorists to reach out and touch us. And let's not even talk about computers, which allow somebody sitting anywhere to be radicalized without leaving his home. We don't need, in 2001 and 2000, we needed the 7 Al-Qaeda people who, for the first time, were Americans traveling to train with Osama bin Laden. We needed them to make that journey to Lahore and then try to get into Kandahar where they could be trained as terrorists. 6 of them obviously were caught, convicted, and ended up cooperating with us in other cases. But we don't need that journey. We don't have the ability anymore to catch terrorists outbound, and then as they're coming back, having been trained inbound, we miss all those tripwires when you can be inspired and get the knowledge on how to harm the good men and women here just by logging on. That's a difference. Greg, well, I certainly have nothing else to add. Can I please ask for a round of applause for these wonderful panelists?
Let me conclude saying this is a magical evening here at the Robert H. Jackson Center. You've exceeded our expectations of what we would possibly want to accomplish honoring the 75th anniversary of the speech by Robert H. Jackson and to have U.S. Attorney William Hochul drive an incredible conversation with this august panel is quite extraordinary. And I want to conclude by something which was part of his speech, where he says, as he was coming towards a conclusion, "Nothing better can come out of this meeting of law enforcement officers than a rededication to the spirit of fair play and decency that should animate the federal prosecutor. Your positions are of such independence and importance that while you are being diligent, strict, and vigorous in law enforcement, you can also afford to be just. Although the government technically loses its case, it really has won if justice has been done." And with that, I draw closure. We stand adjourned, and thank you all for coming, and thank you, panelists, for a special evening.
Yes, yes.